Good everyone, and welcome to this panel on the DPO Universalis. This panel is organized by Uber and is part of the DPO track, a specific track on the DPO function that is organized this year at CPDP. Welcome to everyone.
Yeah.
My name is Caroline Michielsen. I'm a lawyer at Stibbe in Brussels, and I will be moderating this panel today on the role of the DPO in an international context. Let me maybe start by introducing you to our panelists for today. On my left hand, we have Mr. Hilke Heijmans. He's not shown on the slide, but he's still very important. He is president of the litigation chamber of the Belgian Data Protection Authority, and he's also a professor at the Free University of Brussels. Next to him, we have Mr. Renato Leite Montero, if I pronounce it correctly. Yes. Renato is the Vice President of Data Protection, Privacy and AI at END, formerly known as Etisalat END. And before that, he held the position of Global Data Protection Officer at X, or as we've known before, Twitter. Yeah. Next to Renato, we have Mrs. Catarina Silva. Catarina is head of the European Data Protection Office at MasterCard, where she has global responsibilities and often also deals with other jurisdictions and DPOs in other territories. And then last but not least, we have Mrs. Isabel Verreken. Isabel is head of the Secretariat of the European Data Protection Board, the EDPB, and she has over 20 years of experience in data protection. So welcome to all of you, and very happy to have you on this panel today. Maybe one quick practical note before we dive into the topic. We have reserved 30 minutes at the end of this session for questions from you, from the audience. So please keep track of any questions that might pop up during the conversation and save them for the Q&A at the end. Okay, so let's dive into the discussion. As I said before, the topic for today is a DPO in a global context. I'm sure you're all familiar with the role of the DPO under the GDPR. Under GDPR, it's really seen as one of the cornerstones for compliance, and we have quite clear rules on the function of the DPO, on the dismissal protection, on the independence, etc. But what we've seen in recent years, and this is also aligned with the topic of the CPD conference this year, is that the world has been watching. And in recent years, we've seen that other countries around the world have adopted legislation that introduce a similar role to the DPO, or a role that has a similar name, for example, a privacy officer, but where the rules are quite different. So on the one hand, some of these countries have legal frameworks on the position of the DPO that are very similar to GDPR, but on the other hand, there's countries where the rules are very different. And these differences, of course, when acting as a DPO in a global context, can create a lot of challenges, and those challenges will be at the center of the discussion today. Even within the EU, we see differences between the member states in how they shape the DPO function in practice. One example is shown here on the slide. This is from findings from the European Data Protection Board that I'm sure we'll hear more about later from Isabel. But here you can clearly see that different member states in practice have different approaches on the level of independence of a DPO. So we have some kind of harmonization in the EU, but still differences. And again, those differences create challenges for the DPOs in multinational companies. To start the discussion, maybe a first question for Hilke from an academic perspective. I think it would be good for our discussion if we first revisit the rules under GDPR a little bit, while focusing on why these rules are so important and why they are the way they are. So I would like to ask you if you could give some insights on the background of these rules, please.
The background. I remember when I worked at the EDPS years ago in the European institutions, we had this strong mechanism of DPOs, and these DPOs were a bit a network under which the EDPS was working within the European institutions and agencies. And when doing that, we noticed already then, and that's what I would want to do now as well, there's few dilemmas on how this role is put in place. This function is requires means that we have a number of dilemmas which we have to work with. To start with, the DPO should be independent. That's what the law says. That's what the basis is. Should not receive instructions. Although when I read this slide, apparently 20% or something in Belgium of the DPOs do receive instructions. Independence is a nice thing, but independence does not make sense if it's not the role is not done in an efficient manner. So the independence requires, in the first place, effectiveness, and I think that's also when you look at the way it's put in place, it should be influential, this role. So that's why the law says that you should have access to the highest management of your organization. That's what the law says. However, this balance between effectiveness and being close to the management and independence is really the big issue at stake, and I think it's never been solved, and I think every DPO does it in a different manner. If you are fully independent, then you can give nice advices, but no one listens. That's basically what we saw already in the old days at EDPS, and I think that's still the case in many cases. If you're too close to the management, then how can you be independent? So that's a constant balance which has to be made by the DPO, which makes it a very complicated role. There's another element, the third element, independence, effectiveness, and then accountability. Also, if you are independent, you are not a free element, not an electron libre, as the French say it, a free person within an organization. You also have some responsibilities, so you should also be accountable. Well, how to do this? I'm curious to hear from people who work in this fiction how they do it. To get more and more into what is important and how we see importance, what I find interesting in the whole discussion is maybe the internal versus the external DPO. We see more and more that organizations rely on external DPOs, I think. But maybe that's not the right trend, but it's what we see a bit when we work in the Belgian day-to-day life. How can this external DPO independent? That's not a problem. He gets his money and he's very independent. But how is this external DPO can really be influential towards the management, understand the organization in which he has to work? Those are questions which would be interesting to discuss and to put forward. The loyalty of DPO, I think, is basically, if you look at the law, has three elements. You should be loyal to your organization. You're independent, but you should be loyal to your organization. You're the interlocutor to the data protection authority, so you should really be close to the authority, be loyal to the authority. And then finally, you're also the interlocutor for the staff of an organization and for complainants with an organization. Maybe if you work in a company for the customers who think that their data are not dealt with in a proper manner. So these three elements of loyalty. Well, I'm asked here to say something from an academic perspective, so I can put just some questions. How do you do that? And I don't have to give the answer. Internal versus external I find important. When we have dealt with cases before our Belgian authority, for our litigation chamber, we had a few things which always come back. One is the issue of incompatibilities, because especially in smaller organizations, you have a DPO who just does his DPO work. Well, there's no money for it, there's no time for it, so the DPO always has other tasks, which in one hand is useful, because only by doing other work within an organization you start to understand the organization. That's my problem as well with external DPO. On the other hand, if you're responsible for processing operations, there we said at a certain moment there is a sort of red line, because you cannot be the advisor to the management at the same time responsible for the processing operations, which are sent to the management and which the management works it. So another dilemma. What we see as well, and that's the last thing I want to, last two things I want to say. The question is, does this role become more clear after these years? I think to a certain extent, yes. There's decisions of data protection authorities, but there's also some case law of the Court of Justice in this area, the Leistritz case and a number of other cases which made clear what this role should be. And, but I'm not going to say what probably Isabel will say. There is also a need, I think, to further clarification by the board in new guidelines. But maybe you will say something about it, because that's the EDPB has announced already to the public that there will be new guidelines at a certain moment. So those are a few very high-level dilemmas. What I see a lot, let's say, in practice as well, is that there is quite often not enough time dedicated, not enough resources for the DPO role. That's something you probably all, if you are DPOs, you all acknowledge that that's indeed is the case. That in some organizations things are really moving forward. In others, what I see, it's still. When I started, I think in 2019 at the DPA, we saw that the DPOs coming. That was sort of end of career thing. The last year before your pension, you could become a DPO, or you just came from university, and that would also be a nice thing to start. And I think that's changed by now. We also see, and we mainly see in bigger in the commercial area that there are really at several places good DPO teams put in place. MasterCard has always been a good example, so I'm happy that you're here. So that is a starting point.
Thank you very much, Hilke. I think that's perfect for setting the scene. I understand that the perfect level of independence is still quite difficult to find, and that we still need some guidance, or that we would welcome further guidance from the EDPB or even further case law to try to find solutions to some of the challenges that you mentioned. Now, indeed, we're privileged to have two very experienced data protection officers on our panel today. So maybe a first question for Katharina, since you're also working on the global level, and since the topic for this panel is mostly aimed at challenges in the international context, could you maybe explain some of the challenges that you are facing when acting as a DPO on the global level, when interacting with DPOs in other regions, and how you find or how you experience the different approaches to that DPO function in those other regimes?
Thank you. So, hello everyone. So MasterCard is at 210 countries, and as we were mentioning, now the DPO is actually a role that is in a lot of data privacy laws. We have DPOs appointed in, I have to check, but I think it's 38 countries. And if we count, of course, the EA countries. And we are actually kind of now looking to the new laws and see how we do it. Before we decided to appoint a DPO, we wanted to make sure that this is not just a name. We appoint when actually the person is actually achieving and doing the DPO functions, really ensuring the compliance of those privacy practices in this country. As you were saying, we see a lot of laws where they are still not very much mature, as in Europe. And they have, most of the times they have one provision in their laws explaining, that where they need to appoint a DPO, but they don't really explain what is the functions of that person, the independence, if they should really report to the senior management. So what we have been doing in MasterCard is we have created a framework. And we have decided that for the countries where sometimes this function is still not mature enough, we have applied the highest standards, which is the GDPR. So we have an internal document where has a policy status where we say what are our functions, what are the qualifications of this person, everything that we see coming from the guidance that we see here in Europe. And then we have another document that explains internally how people should engage with the DPO, because we are a very big company and we have just a few DPOs, and we need to also make sure that people understand when they need to reach out. Thank God we have a big privacy team, so we have certain topics that go to our colleagues in the broader privacy team, more the BAU. And in this document, in this framework we created, we make sure that the DPO is only reach out for really high-risk situations, when we have potential data breaches, when we are doing, for example, when we have privacy complaints that require the DPO. So we have to make sure that not everything goes to the DPOs, because otherwise we will be full of work and we will not be even able to do the functions properly. And that has been very important, especially for, we have DPOs in Ghana, we have DPOs in Nigeria. Sometimes the teams there are much smaller, and it's very important to kind of explain when do they need to go to one person, when do they need to go to another. And this governance is very important for things to work properly.
Okay, thank you very much. It's good to hear that there are some practical solutions in terms of governance on how to deal with the challenges. You also mentioned that when different standards apply, that the policy that MasterCard applies, that you will apply the most strict level, which is often the EU level. In your experience, is it the case that the EU DPO roles are really more developed compared to others? And does that result in fact, always the DPO EU roles taking the leads? And if that is the case, do you think that this would undermine the independence of the other DPOs? Is there a risk there, or do you not really see that risk?
Yeah, it's true that the EU has been the standard for the other countries, and it's not only for the DPO role; it has been also for other privacy practices. But we try, when we create this framework, we make sure that the independence is key. So we want to create, a structure and documentation that allow us that the DPOs in the other countries don't really work in this vacuum. But at the same time, we want to make sure that we have the right balance to give this local autonomy. And that is very important. And how we try to achieve that is like I was saying, we have already, a big company like ours has, a corporate structure, and we make sure that the DPO role, even in the different countries, they sit in specific meetings. So if we have meetings to discuss risks, like risk committees, we have to make sure that he has an attendance, and no matter if it is in Belgium or no matter if it is in Ghana or Brazil or Nigeria, we have to make sure that they are sitting in those committees. The same audit committees, we have to make sure that they do it. And I think because they have this place on the table in their countries, they are able to exercise their independence and to exercise their autonomy.
Okay, that's good to hear. Renata, you also have a lot of experience being a DPO on a global level and having regular experience with other jurisdictions as well. Currently, you're based in the Middle East. Could you share some words about how those countries approach a DPO function and where the largest differences are with the EU DPO role, please?
Sure. And first, thank you very much for the opportunity over here, fellow panelists over here. The last time I was at CPDP was 2017, so it was a long time ago. It was good to be back over here. And just to, I guess, contextualize a little bit. So I held the position of DPO in almost every single region of the world, like Brazil, Latin America, Europe, and now I am the global DPO for EAND. For those who do not know, EAND is not well known in Europe. And I think this is really good for the connection over here. Is a tech company of the Middle East and that operates in 40 countries, 200 million clients, mostly in the Middle East, in Southeast Asia, in Africa, and also expanding right now to the EU. Now, AI Act is applying to some of our operations as well, GDPR, and also the Americas. And And also not only the DPO function, but we're going to talk about the convergences and maybe some overlaps and conflicts with other functions over here. And one of the things that I think it's very interesting, we always start talking about the DPO function and other matters with GDPR, and I'm going to quote here, apologize in advance, this is what the law says. What I've been learning a lot, and now I literally moved to the Middle East a little bit more than 6 months ago, is that the law is very different. It is very different. Even in Brazil, like where I started as the function of DPO and also as an external DPO for some companies over there, the law in Brazil says that DPO is almost like a point of contact. It's not necessary, and this is what also one of the practical advices. Do go beyond what the text of the law says when you're talking about different jurisdictions. If you see what some taxes that you see in Brazil, that you see in Nigeria, we mentioned over here, that we see it says in Saudi Arabia, what it says in the Emirates, the law says something, they're implementing regulations, there are some guidelines that do complement, and there's a lot of a political aspect that need to be taken into account. So you get, for example, in Brazil, as I mentioned, the first reading of the DPO functions mostly as a point of contact. It doesn't even say add the text over there that is like monitor compliance, advice, and so on. It's basically to communicate with the Data Protection Authority and to communicate with the data subjects. So back in the time we were discussing the LGPD, which is the Brazil General Data Protection Law, there were a lot of back and forth on this and trying to simplify and other things. So we had the Brazilian National Authority to come and complement what was there in the text. If you go, for example, to Saudi Arabia, it has the first reading, which is quite similar to the GDPR. But when it says, when you see things as potential liability, independency, that is written down over there on the general sections, implementing regulation, on the practice of the region, it is quite different. A lot of we take the GDPR standards for independency and resources, and even, let's say, security of the job. When I held the position of global DPO for Twitter and then X, I had a statutory position over there. So it would be really, really hard to be fired under the DPO. That is quite rare in other parts of the world. You go there. So, and when you see something that I mentioned over here, the maturity level that you see, not only the regulation, but the approach of that regulation. When you have to encounter the company, when you see the maturity level that has an impact on where the DPO is positioned, if the DPO receives instructions, if the DPO has resources, if the DPO can act on other things, and even if the DPO is hurt. You see that a lot of times. I am very much that the DPO should be involved in the day-to-day business operations of the company, making its independence and so on, but you don't see that a lot. I really like this story over here that says, back in the days, the DPOs they were either retired or coming back from school over there. Yeah, because it says that the position is just there to fill in the list of obligations that you have under the regulations. There are some regions of the world that is the case. But as they mature, and this is one of the things that I'm finding fascinating as moving to the Middle East, you have a lot of opportunity to provide this level of awareness that we see in regions such as the GDPR. And I guess the geopolitical context that we see that is changing in the world, we do have GDPRs as the golden standards. We as privacy professionals, we still take that into account. But the world is very much saying we not necessarily need to take GDPR as the only standard that we need to follow. We should, maybe there's an opportunity to take the characteristics of the time. You get, for example, in Africa, in some positions, that if we say the GPO has its own resources, its own teams, most of the sectors over there will not have the resources for that. So that needs to be taken into account. A lot of the authorities do take that. And I think an interesting point to say that is how the authorities do see the GPO in the different regions. If you go, for example, in the EU, I had the opportunity to maybe face with all the authorities of the EU. There is the say that we are even here to support your work to help you, to give you resources, to say that if you're having any issue with independence and so on. There are other regions of the world that you see a pressure under the DPO that it may even be the representative of the company. Therefore, it's on the DPO to guarantee that the company is doing the right thing on some other regions, and even regions of the world, and that pressure can come to such a level that the DPO feels a little bit scared of holding that function because of the way that the political environment works. But we can go into a little of that throughout the panel.
Thank you very much, and indeed very interesting to hear that the supervisory authorities have such different approaches. And we can talk later about which approach we consider to be the best one. But this brings us seamlessly actually to Isabel, because Isabel is working at the European Data Protection Board. I've briefly touched upon the differences between member states that we also see within the EU. Could you maybe share a little bit about the actions that the European Data Protection Board has already taken to address those differences and the actions that you're looking at next?
Yes, so with pleasure. Before that, I think, hearing also the conversation, I see, the evolution of the GDPR, and we talk about other regulations that are eventually worldwide influenced by the GDPR. Then I would like to go back, because having MasterCard next to me, it reminds me old stories. Because in fact, before GDPR, there were no DPO duties. There were no, except in Germany or some countries, but it was not mandatory to have a DPO. And then I was working at that time when the Belgian Data Protection Authority, where now Hilke is working. And then we developed at European level those binding corporate rules to enable data transfers, like free flow of data within big firms. I mean, those multinational companies that want, in fact, to be a bit privacy champions. And one of the criteria to be entitled to benefit from this free flow, as if it would be a European flow, was to have a DPO network. So meaning that it would have, it's a kind of course, it depends on the organization or how it's made, but in practice, there are like one base in Europe, but also liaising with different DPO, and then it's a kind of sometimes office with technologists, etc. And I was reviewing at that time a lot of DPOs, and in fact, I was the lead authority for MasterCard, where they made the BCR processor in controller. So if MasterCard had also this development and the policy that they made is also found it's not on the GDPR, but in fact on the binding corporate rules. And they were in fact already developing those network of DPOs even before the existence of the GDPR. So just because I was reviewing that BCR, so you can see sometimes also the influence of a tool which is made for making international transfers, and most of it, in fact, have been embedded in the GDPR because there is a lot of element of binding corporate rules that have been developed there. So sometimes also the practice is coming also from the business, influencing the law, and then after becoming also a standard that can then be deployed worldwide. So that's also interesting to note. So now coming back on the role of the EDPB, so what we are doing, so we are gathering all the national data protection authorities. That's a European body where our main role is to have consistent application of data protection law in Europe. And one of the actions that we are making is called the Coordinated Enforcement Framework. It's every year we decide on a topic on which we invite all our members, and even beyond that, like the DPAs, even all the Landers DPA in Germany, to be part of a joint enforcement activity. So we take a topic, and then everybody, all the DPAs, they can then participate. In 2023, it was about the role of the DPO. Why? Because you made reference, it's a cornerstone of compliance. Yes, it's also a very good partner for DPAs. To have compliance in practice, it's not only about enforcement, etc., but also to reinforcing the role of DPO within the organization. So we wanted to see, to make a state of play, and you made difference, a point internationally that the law might be different to the practice. This is also the outcome of this activity also in Europe. So we had 25 data protection authorities in Europe taking part in this action of the CF on that year, 2023. And we contact in Europe 62,000 organizations. We got 17 answers. And so it was a sending questionnaire all around Europe to controllers, to DPOs. And then there were also some audits that were made, sometimes investigation, etc. 145 audits, I think. And then we gather, in fact, information. Then we produced a report on the basis of that action. And there were, I think, very important conclusion relating to the independence of the DPO. For instance, on the incompatibility of the task, that's the instruction ones. So there is a ban to receive instruction in the exercise of the DPO activities, and you can see that the median percentage is 14 in Europe, that the DPO are receiving instructions, which in fact is unlawful. And then I gave you, I think, other slides as well. You don't have it?
No, it's not. We don't have them available. Sorry.
Oh, you didn't want to add. Okay, that's okay.
The difference.
It's okay, because there were other ones that were nice too. But then you can read the report, you will have access to them. So they are also about the incompatible task, as you are saying, that they were, we had many DPOs be in charge of drafting the DPIA, while in fact they should be just consulted for an advice. And more than 20% belong to the highest levels of management, even CEO or head of department, taking decision on the purpose of the means, which is contradictory to case law, I mean, from the law, but also we also have a case law at the European Court on that. It's XFAB Dresden case. If you are interested, it's C 453/21. And the last point was about the reporting lines, because very important to have an impact in the organization. I think you can take the role of DPO in practice as just being a compliance person, making papers, producing reports, etc. Or you can also try to have an influence in the way also the organization will go through. And that's important to have this access to the management level. And we checked how often that was taking place in practice. So for 50% of the cases, they were contact only 1 or 2 times a year. But then what was really more worrying, that 20% of the time there were no reporting at all, and for 17% that was not even expected. So we saw this problem of the law and the practice, and so we decided to make different actions for that, raising awareness at the national level, enforcement action as well, to show a bit the way if it's needed. And then we will also update. We already made guidelines on DPO back when it was a working party 29 before the entry into application of the GDPR. And we will add some clarification on some concrete case or element that we learned as well from the CF, but also from the practice at DPA level. And yes, that's all those actions that we would like to make to try to improve, I would say, the situation of the DPO, which is important to have compliance in concrete within the companies. Thank you.
Thank you very much. You mentioned a very interesting point, which is that often business and practices influence the law eventually. Renata, you also mentioned before that your advice would be to go beyond what the law requires in many situations. Now, I'm working as a lawyer, and we don't regularly advise our clients to go beyond the law, not that often. So an open question to the panel is, do you think we would benefit from more legislation on the DPO function, besides more guidance from the EDPB, but is there a need for stricter rules or more elaborate rules in the GDPR or in other regions on the DPO function? It's an open question, so whoever feels like it can respond.
Let me, as a DPO, sometimes it would help me. Yes, as a DPO. And for example, one of the things when we were preparing for this panel, we discussed about potential personal liability of the DPO, which is something that in the GDPR is not a thing at all. It is a thing in other parts of the world, okay? And normally these personal liabilities that even come from directly of the data protection law of that particular jurisdiction. When you have that particular reading, you say, okay, it is a function that I am protected, it is a function that I am independent. But then when you go to read the text on liability, and I can mention some jurisdictions over here too, already, like Saudi Arabia, we talked about that, Nigeria as well. And it even says that there's potential of the legal, both the controller process and the person can be held liable if for other functions they, on purpose or gross negligence, they do they obstruct the investigation, or they provide a wrongful answer, or even if they don't fulfill particular obligations that it's in the data protection regulation or implementing regulations where you see that in a lot of countries. So in those and this is quite present in jurisdictions where it's very political. The interpretation of the regulation is very linked to the political environment. And if you have some additional regulation that provide additional protections, that'll be good. If this is not the case, is that organizations expect that they come to a maturity level, such as MasterCard and others here, that, okay, internally, we know we are in a jurisdiction, we have to appoint a DPO, either as a global DPO or regional DPO, as MasterCard mentioned over here, that you have internal protections. So things such as indemnification clauses, as insurances. I had to have insurances in a lot of jurisdictions because one thing is say, okay, this person is not going to be held personally liable because this is one particular interpretation of the regulation. Another thing is to undergo a legal procedure, to open a legal procedure and even a criminal procedure in some jurisdictions against those who are considered an information officer, data protection officer, representative of the company in direct contact with the authority. It is a thing. So the company, the policy of the company should also create this internal protection and the support that can be given to the function of the DPO.
It's very good to hear about all those practical things in terms of governance that companies can think about to help the DPO. We have been mostly talking about large international companies, but what if we look at smaller companies that are still operating in an international context and that do not have all those resources to set up a DPO team or a DPO office? Do you have any practical advice for those smaller companies, Katarina? Like, what priorities should they look at? Is it the reporting lines? Is it the independence? How would you advise them?
It's a very interesting question because I receive a lot of comments usually from my colleagues saying, "Oh, you guys are so big, so it's very easy to be independent and have that structure." But before I joined Mastercard, I actually worked in consultancy, and we were advising much smaller companies. And to the point that Isabel was making, that we have today DPOs actually doing the whole DPIA, I think that the secret is really to leverage the network, as we were saying. So if you don't have a big privacy team, work cross-functional, make sure that you create these DPO champions, the DPO network, whatever you want to call it, but they can help you to exercise their role. And that way they can do tasks, daily tasks, that can be filling the PIAs, providing advice, and then the DPO can still have this step back and have this more second line advisory role and still keep the independence and actually exercise the functions as they should be. And I think this is really my advice for small companies. Work cross-functional, or with your security teams, with your legal teams, wherever you sit in the organization, but try to find partners that can be a little bit the champions of privacy, and then put you as a second line to still be able to guide them and make sure that actually they are making the right decisions.
Yes. If I can briefly comment on that, because it is still quite common in mature, medium, and small organizations to see the DPO or the privacy function as a blocker. Yeah, I see a lot of people here is nodding. Yes, so you've been facing that. And if the DPO can demonstrate from the smallest company to the biggest one that it is not a blocker, but it can be an enabler, and then compliance and can help achieve business purpose and also innovation in change in governance, and that's like the biggest start that you can have. So when even working with, I had the opportunity with some colleagues to even develop some guidelines for smaller companies to say, make them come to you to say, we need to work with you in order to be enabled to achieve the goals of the organization whatsoever. If that is possible, which is quite hard, regardless of the level of the company, the rest becomes way easier.
Thank you. Hilke, with the mechanism that Katarina has described before, would this pass the test of the litigation chamber, do you think, or do you see any issues in that approach?
I think it's too difficult to say if it passes our test, but I think a few things are important that have been said. For instance, the last thing Renato said about the DPO as a blocker and not an enabler. When we talk about data protection in general, this is the whole story all the time. How can we make, and that's our task, I think, all privacy professionals, not only DPOs, to make it visible that data protection is not blocking progress, but it's helping to develop things in a responsible manner. This is getting more and more difficult in the last year, I think. If I look what the European Commission is all saying, it's all to get rid of all those detailed rules and ensure that we work on innovation, etc. So this is our task. I think there's also part of the DPO, and the main task is maybe to be something more than a bureaucrat who does his work, but ensures and does work on awareness raising, on awareness. You don't need extra rules for that, but you need indeed to have people who are convincing. That might be also part of the role of the DPO, I think, to be convincing in the big thing. The other part, of course, I pick on a bit what you said, Renato, is also the liability issue and the risk you have if you speak out too loud, etc. I think that's a clear thing. I don't think in Europe there should be new laws on that, but it's something we all should keep in mind. The other thing, I think, for smaller companies, what is the best thing to do? I don't have an answer to this, but I think it's important to work with what you said, I think, in terms of networks and to work together and to bring networks together. I think that's also what we are doing here, what people do here in Belgium, to make networks of people who speak the same language, who work together, who don't only talk to each other. I go a bit maybe beyond what the question was. I don't answer your question.
No, that's
I don't
perfect.
answer your question, in fact, but I give some further observation. The network thing, when we are now, as Belgian DPA, we have just been, our mandate has just been renewed, so we're thinking about a new strategic plan, and one of the things is how can we become more influential? That's on the one hand to work with our network of DPOs, but also to work directly maybe with CEOs or with boards of organizations, to make them understand that this is not blocking, but this is something which needs to be done in a society which quickly changes. And there's still a lot has been done over the last years, but I think still this is still not evident everywhere.
No, and there's certainly still work to do, which is good for us as privacy professionals. There's one other topic I would like to address with the panelists before moving on to the questions from the audience, and this is about the work that the European Commission has indeed been doing in the last years with other pieces of legislation, because we've seen new instruments such as the DMA, the DSA, the AI Act, and certain of these instruments also introduce a new role of compliance officer. My question for the panelists is, do you believe that those roles would be compatible with the role of a DPO? Is there any guidance that we can expect from the supervisory authorities? And how do you address this at the moment?
Yeah, I can already say that this is one of the topics that we are going to address with the updated guidance on the DPO. I cannot already provide an answer because the guidance is not yet there, but wait for a year. Because I think it's normally for 2026, this guidance, so then there will be some, we need to analyze indeed this question and then to come up with some guidance on the matter. But I will be very interested to hear, I don't know, from the practice, if you already have some views on the matter.
So for an experience here, when I was at X, because we had what I'd like to consider a pretty well-developed governance structure for the privacy team, now, which was, it had from privacy legal, privacy operations, privacy engineer, privacy policy, privacy risk, and you name it. So because of this structure that was able to run the other functions together with being the role of DPO and interacting directly with the national data protection authorities and also with the European Commission because of the other regulations, such as the GSA. So I was asked to develop the governance structure for the GSA function when the company was considered a VLOP and therefore needed to comply over there. And for a time, not only when the GSA became into effect and before the company hired someone that was specifically the GSA compliance officer, I also had the position of GSA compliance officer, but together with the DPO. And one of the practices that we had at the team, we were always very transparency, blunt, and like to cooperate and collaborate with the data protection authorities. So one of the things that we like that whenever there was a change in the structure of the team, or the governance structure of the team, we sat down with the data protection, with the authorities to explain, okay, this is what we are envisioning. What are the pain points that maybe we can work together? You know, data protection authorities are not there to provide any legal guidance, but like because of the collaborative spirit that there is when you go there to show this, you can like there was always a way to say this seems to work, this potentially doesn't seem to work. So at the time, talking with some of the data protection authorities that that we were subject to on different matters, they said as long as the function and the time dedicated and everything does not make the functions of the DPO incompatible in the sense, how much time are you going to dedicate to this? Because you do need time. At Twitter and both X, the team was not big, so therefore there's a lot of hands-on, and there was a lot of preoccupation for the authorities. How could the team handle everything? So we had to demonstrate that even with this additional function, we were able to fulfill our obligations. After that, there was a person that was hired specifically to fulfill the role of DSA compliance officer. This was not at all any direct guidance for any data protection authority, but was the sense of, let's say, we are building this as we go. And another thing that I always enjoyed, organizations sometimes, they take data protection authorities and other authorities as like the final, that they know everything, that you go there, and they will have all the answers and when analyzing situations. It is not the case. A lot of them are learning about what is going on as we are. We were talking before about an AI and everything. I remember talking with some of the authorities when generative AI came and said, what is this? And as like the companies who were developing the models and putting the services in the projects in the market, they were also learning of this. There's a lot of corporations. It's very, when you have some type of this research that the European Data Protection Board did with the DPO function, but also when you see other authorities asking for the private sector and industry and academia to go there, okay, we need to learn and we want to learn from you, so let's work together.
Yeah, I think it's very interesting to hear about that dynamic and to hear that there's a relationship of cooperation between the private sector and the authorities, which might shape new guidance or new legislation based on real-life events. So that's good to hear. Thank you very much. I think we can now move on to questions from the audience. Does anybody have a question for our panelists? And don't be afraid, they're very polite.
Is it the thunder before the question, yeah?
I think my question was coming, but well, you mentioned the tension there is between jurisdictions and the different descriptions of the role. My question is, how can you ensure being independent from a European standpoint of view? And when you are perhaps limited to what you can say from the point of view from another jurisdiction, so that would basically affect your independence in Europe. Is that correct, or do you see it differently?
About the framework?
Yeah, I'm happy to take that question if that's all right. And I can give a real example. So one of our DPOs, we have a DPO appointed in China, which is a country that, from an employment law perspective, doesn't have the same protections as, the European countries. And again, and with kind of feeling that I'm repeating myself, I think creating the framework is very important, right? Making sure, for example, that this person goes to the board once a year to present their privacy practice and has the right to speak. And of course, the whole culture of the company is really to speak up. But there's also other things we can do. If we see countries that have, weaker employment laws, or we see kind of employment protections, we can also address this through the contracts, right? We can put provisions, we can put insurance to make sure that the person can actually feel that they can speak up, that they can be independent, and making sure that they go, to different meetings, are able to explain, what is going on, what is their advice, and what do they see. So I think governance here is really an important thing. As I mentioned, we have risk meetings, we have audit meetings, and making sure that the DPOs have a place in the table for us is very important, because it allows them to actually have a forum to speak.
Sometimes you don't fly to the place. Yes, this has happened. So in situations where, like, in the ideal world, you would have a framework, an internal policy that gives all the protections. You would have all the even as I said, insurances and DNO that would protect and say, you, like, our standards here is to be independent. You need to be separated and everything, even if there is an external pressure for not only authorities, sometimes even the police. It has happened before, and there has been situations. Unfortunately, I have been subject to situations where the company decide, like, you cannot fly there, or we're going to appoint someone because the law mandates that there needs to be a representative called anything, DPO, you name it, that needs to be in the country. There are contracts that are over there, but that's what I said. Ideally, the law, data protection law, should have this protection, but in practice, sometimes you just can make it. There have been many jurisdictions in which, like, even personal security, if there is a need to fly over to be in there in person because from what is a business interest to address the situation, security corp, like that kind of thing. It's very country by country, political situation for political situation.
Just ask, maybe return the question a bit. Within Europe, is there a difference between member states which makes it difficult for DPOs to function? That's a question I have. For you, yeah. I see that it's very nationally organized. We have all these DPO networks on national level, but is there an issue also within the European Union which need to be solved? But maybe it's a question for later.
Yeah. Ask me a question. I'll give you a promise. Perhaps it's good for people to understand who I am. Otherwise, they wonder perhaps why are they asking that guy in the front. My name is Ricardo Catalan. I'm a senior inspector with the Dutch DPA. I lead the DPO team there, not the internal team, but I also am very active in the area of DPOs. The question was that what are the differences on a European level?
But let's say
right. What we see is that the DPOs on the European level are converging. So there were huge differences back in 2018, and they are growing in the same direction. So one has grown much faster than the other, but we see the same solutions to the same problems. We see networks coming up of DPOs. We see guidance being drafted on a national level. The EDPB, as said there before, is drafting the guidelines on the EDPB level. So it's all converging to the same thing, and the profession of DPO is maturing, and I think that is really important.
There are some differences, for instance, in Germany, where the reason why you can end the termination of the contract would be, with the level will be higher. I think in Germany, we saw that from the European Court of Justice, because they had to answer the question whether having a higher level of protection is compatible with the European one. And then the reply was, yes, it is acceptable up to the moment that you cannot prevent to end the operation when there is an incompatible task. So just to make it, we learn it also from the Court of Justice and the German cases.
Good afternoon. Erik Valgaarde from Stibbe. Thank you for a fantastic panel. Special mention to a great moderator. No bias. I wanted to open up the discussion a little bit to cultural differences, because obviously GDPR, I think we should all agree, it's based on shared values, shared visions that we have on privacy as a right, et cetera, et cetera. Now, as a DPO, when you operate on this, let's say, global scale, cultural differences in the way privacy as a concept, in the way companies act, et cetera, are probably there. I mean, even for us lawyers, we need to be mindful of cultural differences. The question is, how do you deal with that? Because in a DPO team, even of a very large company, you cannot have a specialist for each country in which you are. So what are the solutions to the extent that you sense that this is a relevant factor? Thank you.
I was hearing your question, I was thinking, and I hope with my answer I don't offend anyone in the room, but one of the things that we do in MasterCard is that the DPOs have the obligation to do this DPO report that then they present to the board, which is supposed to be a summary. And to your point of the cultural differences, we try to follow the same structure, the same index, but it's interesting to see that, for example, in Europe, we see that there's a lot of appetite to see metrics, to see trends, to see numbers, and take conclusions out of that. And now we have also DPOs in Latin America, in Colombia, in Brazil. Again, I hope I don't make any, but this graphics, this metrics doesn't say anything to them. And they really want to follow a completely different structure. So it's although we try, and this goes a little bit back to the point that we need to give autonomy to people to speak to the leadership and to make sure that they are passing the message. So we don't follow the same structure anymore because we do have these cultural differences. And we see in there that there's not so much appetite to have metrics. They prefer to analyze the problems from a different way. And we just present the problems in a different way. So this is, for example, one of the examples that I see in practice of these cultural differences. Yes.
Right.
One of the things that I'm still seeing also is that the regulators in other countries that are having very recent privacy laws are also very willing to learn. We have recently applied for PCRs in Saudi Arabia, and the regulator was very honestly saying, this is our first case. We are also learning from you. Yes. And I think this is really important that the regulators are having this dialogue and also assuming that they are humble and they want to learn from us. It's really a both-way exercise.
Yeah. So I'll get Saudi Arabia, for example, because I recently had to do overall compliance with the Saudi Arabia data protection law and working with SEDAIA, which I am positively impressed by how much they have developed over the course of when the law came into effect. So the GPO networks that we've been mentioning over here, they have, for my supported me a lot. So for example, when I started to fulfill the function, I was not DPO, but I was like the long arm of the DPO for Brazil. We created a DPO network over there. And then I had to do Latin America. I had no experience of the, again, GPO network to understanding. And every time that I had to talk with not only data protection authority, because depends on the jurisdictions, you have to talk to different authorities. And like sometimes you even have to talk with law enforcement. And then you have how to deal with that. You have no clue at all. So talking to those who have been facing those situations, sometimes it's not only DPOs, but other functions does help a lot. In the Middle East, I literally moved to the Middle East 24 hours before starting the new job without not knowing every there. It's kind of talking to everyone. So Saudi Arabia right now is getting there. And I like Sedaya is a really good example. They say they are very active right now, but we know that we are learning. And then you talk with people that have been in the region for longer and say, this is the reason why Sedaya is so active. So there is the political context, there is what they're trying to achieve by being so active. Why is the region not doing? Why is this authority before operating this way, whereas other authorities also has jurisdictions operating this way? So the networks, when I started the GPO position also in the EU, and like X was subject to the GPC as well. Even the GPC, there was a DPO network over there. There was an European DPO network function as well. That kind of, so it was almost like a therapy session, a group therapy session. Yeah, where we said, these are the pains I need to understand, like without like a Charterhouse rule, keeping the confidentiality, but you show the pain points and you learn from them. Being humble, say, I'm getting to an entire new environment and place, what I need to know, and you're going to commit mistakes. If the authority is also humble enough to say, we are going to also commit mistakes, let's work together.
Any other questions from the audience? Yes, there's one over here.
Hi, my name is Florence. I also operate DPO as a service for some clients and sometimes globally. I have a question for our panel. How do you reconcile KPIs from your DPOs locally sometimes, seeing that because of cultural differences or how you operate in several countries, those might be different at some point? Because you have to, we discussed the DPO as an enabler instead of a blocker, which I totally agree is an essential way of functioning. But then you have to find the right metrics, I guess, also to report. Could you maybe share experience on that? Thank you.
Well, I brought the topic. So I think the metrics have also to be analyzed, considering the country, right? And I can give you an example. In MasterCard, and these numbers are public in our website, so I'm fine. But for example, Brazil, due also to the dimension of the country, is one of the countries where we have more privacy requests. More data access requests, more data deletion requests. So if we just look to the numbers itself, we would not. But if we also have to analyze that in relation to the dimension of the country. We cannot compare Brazil to Luxembourg, of course, right? So I think that we always have to look to these KPIs, to these metrics, always considering a little bit the country and dimension. I mean, even for countries that now are starting in privacy, like especially in East African countries, of course that the metrics are much low, but that's normal because they are just starting. So we have to see the trend, right? What is this, trimester compared to the other trimester? What is this year compared to next year? And I think it's important to always keep these trends more at a local level instead of looking overall to the numbers because they might be not really telling the whole story.
So what I experienced from metrics is that they can be deceiving. Because a lot of times you see, there are not a lot of consumers requesting their rights because they're not aware that they exist. or that the teams that are supposed to receive the requests, they do not route it because there is no internal awareness for that. So you have, and it's how you have a governance structure, you have a policy that is for the company, you have had like mandatory training, but you have the different channels. And then you have the consumer channel that is receiving some requests that is not routed to the privacy team, that does not go to the metrics. You have a lot of people developing their own products when there is a privacy review process over there, a data protection impact process, but they work in silos. So you see, oh my gosh, all the projects that are being launched, they had undergone the privacy reviews. In any case, it's not. And then you see an advertisement in the middle of the street of something that was launched without you knowing. So I say, like, you can trust metrics and KPIs. They are as trustful as the level of awareness of the organization and the maturity level of the region. It's like, if there is no awareness and working together, like it can be really deceiving. And then the DPO reporting, you have a DPO function report to the highest management function, reporting to the board, and say, oh, there was no data breach at all. And then you talk to the different areas, different like for example, I work at a group, the group company, different verticals, and then you talk with them. Oh, sorry, we didn't know there was a channel to report data breaches. And then how do you know about data breach? Because they lost a contract. So the level, the metrics necessary in order to enhance the program, enhance the operations, to get buy-in, to get budgets, to get resources, to get everything. But you're not gonna get accurate metrics and even achieve and meet the KPIs that we have if there isn't a proper awareness and buy-in from the different functions and business units of the organizations.
Is that a response to your question?
Yeah, yes.
So when you can't trust the metrics, then you have to find other ways.
Sorry, other ways to convince them. And I find, and maybe you have something, an experience to share or best practice around that. Sometimes another way is to show how a DPO can help the business in a way, or the organization in another way. For example, innovation. If the DPO is involved in a new project, and thanks to this, the questions and the compliance check that he's actually performing, you are innovating in a better way. I have experience from that. That's another way of getting some buy-in, I guess.
Yeah.
So that would be an interesting track for DPOs also to function.
And the fines for the authorities.
Yeah, exactly.
When you talk about these buy-ins, for instance, it's very difficult, I think, for you to make it measurable what you do, because you do all these different things, and sometimes you do small things and you have an enormous effect. So I'm curious what you do, because I think things you do as DPO is the same problems we have as a data protection authority. We need also to show that we are needed, that we do, you have to justify why we spent all this money. And it's the same way. So maybe by imposing fines, it's also good for us, because then we give money to the state. But it's
We have some time left for some other questions. Do you have any in mind that you would like to ask our panel?
Well, I have one question. I'm Alexandra Stanford, a student at Tilburg University, and I would like to thank the panelists as well as the moderator for bringing such an important discussion, because DPOs, I think one theme that resonates with DPOs is that you do a lot with very little. And I would like to ask a question regarding the last point of your panel discussion, with the different compliance officers that might be added to the DPO role, right? Would the term team, data protection team, be whispered or might be considered, not only to take into account all of the additional responsibilities that DPO may have, but maybe to also force companies to give a little bit more resources, a little bit more attention to the DPO role in order for DPOs to do their job effectively.
So the question of resource is something, you were saying that the DPOs are doing a lot with little resources. I think DPAs as well.
Mighty teams, mighty teams.
So for sure, if you do, there are a lot of regulation to put in place. DPAs are also, in the same way, DPAs are also involved in those national regulation, additional regulation, digital regulation. It's a bit normal as well that within an organization, it's moving from a personal data to a data governance,
Yes.
and having some different questions to be addressed. And of course, if you have more regulation, if you have a company that would like to comply with legislation, normally they need to give the resource to be able to comply with it. And if you have also a network or a place where you can have different compliance questions to be discussed about different framework, you can also try to ensure some kind of consistency within the company. So that's also something that is important. But as it was already said, I think that what is really important is to demonstrate the usefulness of data protection compliance, to show that also you can also differentiate yourself as a company by also being more ethical and having also more trust. We have seen some very large company losing trust in very fast manner, and then losing a lot of, it did happen. When they were on the new conditions of WhatsApp, and even if it's funny because it was the change was not even due to that updated condition, it was in fact since 2018. But then it created a kind of buzz, and then there were so many people downloading Signal and Trima, and so that can happen. Or when there is a data breach, something that is even more severe. So the trust is also very important. And thinking back also on the certification, code of conduct, compliance rules, etc., binding corporate rules, that's also, I think, a way to try to demonstrate that you can achieve compliance, and you can have a kind of ceiling, or you can differentiate yourself as being a privacy champion as an organization. And I think this is very much rewarding as well for the DPO. All the DPOs that I was doing that for 10 years, reviewing binding corporate rules, and all DPOs that went through those processes, at the end of the day, was also deeply recognized within the organization, because they were taken very seriously at global level, having developed really all the privacy policies globally, etc. So that's also another way also than KPI to be recognized, I think, from the manager.
I have any strategy that I like to use is work with particular pilots within the organization and fix, working with this pilot, show how the compliance with the applicable regulations, which are not only personal data regulations anymore and others, how it can help them achieve what they need. It can be, for example, a contract that they are negotiating. So they have a third party that is trying to hire them as a processor, for example, and they request, okay, we need you to provide a report of your level of compliance with this regulation, so on, GDPR, others, and so on. And then you work closely with them and demonstrates, even from a business perspective, how the work from the privacy team, let's call it the different functions over here, help them to close the deal. And it can be a small thing, and use that as a case to showcase, sorry, being redundant on the word on purpose, a case to showcase how it can help. It helps a lot as well to see the privacy function, DPO function, regardless of where it sits, on legal, IT, cybersecurity, HR, if it is a totally independent function, you have it as well. It's not a blocker, it is an enabler. So you have, this helps depending on, regardless of the maturity and of the company. It's what is the chilling effects out of this, in a lot of times, because the areas and the teams, they talk with one another, is that you notice that other teams will come to you, to your team, to say, like, can you help us with that? And then you start to develop a strategy over all that. So instead of just saying, these are the obligations, hold hands with them and help them achieve what they need to achieve, also to show to their organization that they're doing a good job, good work.
Thank you very much. I think one of the red lines in this discussion was the importance of communication, connecting with each other. So let's keep doing that during the break. Please join me in thanking our panelists who did a great job, who brought very interesting topics. And thank you all for your attention.